Hello, happy Monday. My name is Michael Leeserman here with the Trial Guides tip of the day. It is September 23rd, 2024. Our tip today comes from Bill Barton's book, Recovering for Psychological Injuries. Here to read today's tip is Bill Barton. Welcome, Bill.
When you preempt opponents by beating them to the punch, you gain credibility. Present the issues fairly, but from an angle favorable to you. Be decisive. Well, let's talk about that for a second. I want to first put in a shameless plug in from my friend Keith Mitnick and his book, Don't Eat the Bruises. Chapters 13 and 14 are state of the art. 13 is owning their favorite facts. That's preemption, thank you. And chapter 14 is in context versus out of context. So that there's a 3-step process to this. One, if there are bad facts, you file a 401, 403 pretrial motion in limine to exclude those. Even if they're relevant, it may be prejudicial. If you can't exclude them, then you need to go to Keith's next step, chapter 13, which is to own the facts, if you can. And that involves looking at your rules, the instructions. What can you do? Like as is, preemption, causation, the straw that breaks the camel's back, your analogies. And I try to own everything about the case that's coming in that's unfavorable and turn it to my advantage by reframing the question. And people that are fragile with many pre-existing problems, it helps explain why it took so little for them to suffer as they did. So you can actually blend a heavy list of pre-existing problems into explaining why it took so little, the straw that broke the camel's back, on causation. So think about that. And when you present the case, I think I like to talk about framing with the jury selection. What deficit does my client have that might not play well with the jury as an as-is or a preemption problem? And I try to find a way to frame it with the jury. Example, what's big to you but little to the world? And I take what my client's problems were and show what little they had left and how important it was. And that's a nice way to present it in a very humanistic way. And it gets the jurors thinking, there but for the grace of God go I. Even though I may be different in form and my problems are different than theirs, we've all got problems. We all have burdens. And that's the stuff of preemption.
Wow, there's so much there in what you said, and something that I'm thinking about because I've seen you do this in person, and it's so impressive. You have a method with A and B and C, and you
Yeah.
actually go so far as to write down all of the things that most lawyers would be afraid of, to write down those things that your client had going on that most people would see as a negative before this
Yes.
happened to them, and you use that to bring to a baseline. It's brilliant. It's brilliant. Maybe just say something quickly about that for
Sure,
us.
Michael. Well, I want to give credit in passing to Marvin Lewis and Mo Levine here. They're the godfathers that left this moral legacy with me, so I never like to use it without honoring them. Now, I have an ABC. A B is a liability event in the middle. An A is a plaintiff's condition before. And a C is a condition after the liability. And dollars is equal to actually A minus C. So if you were a 6, if you were 10 was an Olympian and 0 was dead, and you were a 6 and you were walking down the street and somebody hit you with a car and then you were injured and afterwards you were a 4, it would be dollars equals 6 minus 4 caused by B, the liability of it. That's classic stuff, Aristotelian logic that you learned in law school. I get that. But often you have very fragile people that aren't a 6. Maybe they were a 1 or a 2. And you want to make the difference between the before and after big, because that means more money. No, that's a quantitative subtraction model, A minus C. Marvin Lewis gets the credit for bringing in, and he would actually take his clients down on the pre-existing list by listing all their fragilities, all their liabilities, all their deficits. And maybe they were only a 1 or a 2 before they were hit. And afterwards, they're a 1/2. I'm making that up to overstate. And that's where Mo Levine comes in and said, it isn't what you take from them, it's what you leave them with. And that's a qualitative assessment instead of a quantitative subtraction one. And it's really effective. And it allows you to take a lot of cases and a lot of plaintiffs that are not very marketable under a traditional subtraction model and be very effective.
Wow. Thank you for sharing that with us. If you want to learn more about this, get Bill's book, Recovering for Psychological Injuries. He spells out exactly how you can do this. It's brilliant. Thank you for everything that you do for us and sharing
My
your
pleasure.
wisdom.
And thank you, Marvin and Mo.
Absolutely. Let's take a deep breath together and be aware of being alive, being grateful to be alive today. May we work today to reduce suffering in the world. May our efforts as lawyers and as people help to repair the world. May we fiercely and compassionately advocate for our clients and champion their stories this Monday. All right, I'm going to ring a bell 3 times now. This can take you into a meditation practice, a prayer practice, or just remind you it's Monday. Go out, do good things, and have fun while you're doing it.